will now explore the most relevant parts of the excluded property that is likely to exist between parents and children. This includes gifts, inheritance, property held in trust. We'll be discussing these later and also talking about some options not specifically covered by the legislation, such as loans. Excluded property also includes pre-relationship assets, which are assets owned by your child before they get into a serious relationship with their ex. Subsection G says that property derived from property that is excluded is also excluded. So for example, if your child sells a house and buys a new one, then the amount of the payment to purchase the new home is excluded.
But a word of caution here, because while the initial amount paid to purchase a new house is excluded, the increase in value of the house is family property and has to be shared with an ex. And to be clear, this is not just a house, it's kind of any excluded property that increases in value, but we're using a house as an easy example here. So if your child sells her home for $1 million and purchases a new home for $1 million, and that property goes up in value by $500,000 during her relationship with her ex, that $500,000 increase is shared between them. She'll walk away with $1.25 million, and he will walk away with $250,000. Now, in that example, the excluded property is sold and used to buy another excluded property. But if your child was to sell her house, go to Vegas, and blow $1 million with her ex, and they had a grand weekend, she isn't able to reclaim those dissipated assets. She can't say, I had $1 million that was excluded property and I don't have it anymore, so I would like to claw it back from our other family assets, so you need to repay me that amount. That's not how it works. It's only if it's used to purchase something else that is then has value.